In this instance, our client slipped and fell on 2 different days, 3 months apart. This presented an unusual situation. Of course, most times a client comes to us, they've been injured on one day, on one incident. My name is David Scher. I'm a partner at Block, O'Toole & Murphy. Our client was a construction worker working on the renovation of a Long Island Railroad train station. Our client was injured when he slipped and fell while working on the pitched canopy that covers the train station where the passengers wait for the train. In this instance, our client slipped and fell on 2 different days, 3 months apart. This presented an unusual situation. Of course, most times a client comes to us, they've been injured on one day, on one incident. This client was injured the same type of way, but on 2 different occasions. On both occasions, it was raining, the roof was slippery, the people running the construction site, which included a general contractor, did nothing to help remediate the situation or make it less slippery. They could have, for example, stopped the work, understanding that it's dangerous to work on a pitched roof that's slippery, or they could have provided something on top of the roof to make it less slippery. They did neither of those things. So our client slipped and fell and banged his knee hard onto the roof. This happened one time, and his knee hurt, but he continued to work. He's kind of soldiered through it. He showed up the next day and the day after that. 3 months later, with his knee still being sore, still trying to work, he's back up on that pitched roof again. It's raining again, and he slips again and hurts the knee. This time, he hears and feels a pop. He goes to the emergency room. It turns out he has multiple tears, needs surgery, and misses a significant amount of time from work. Our client was a hard-working man. He had been doing construction his entire life, since when he was in his 20s, up through his mid-50s, which is the age he was when this accident happened. As a result of this knee injury and surgery, he couldn't do construction work anymore. And that was a huge loss for him. That was a big part of his identity. It was what he did when he woke up in the morning. It was how he took care of himself and his family. And the work was taken away from him because so much of what he did involved needing to climb ladders and bend and kneel and stoop. And his knee, with multiple tears, surgically repaired, just couldn't hold up well enough for him to continue performing that type of work. He was also an active person outside of work. He liked to play softball. He liked the outdoors. He would hike, he would fish, he would boat. Everything became much, much harder. Some things became impossible, and everything became less enjoyable because he had knee pain with all of these types of activities. Our approach on this case required a little different thinking, and that's because this client had 2 incidents, but they were 2 incidents caused by the same defective, dangerous condition, a slippery pitched roof that caused him to slip, and the same entities were responsible for both of these falls, mostly the general contractor who was supposed to be in charge of site safety. We did some research, we did some thinking, and what we decided to ultimately do is to file a complaint alleging both incidents and both injuries in the same document, the same complaint, under a theory that's called concurrent causation. Concurrent causation is a legal claim that can be brought when a client has an injury that can't necessarily be specifically attributed to one incident or the other incident, but it's clear that both incidents to some degree contributed to the condition. So here we had a client who had a badly hurt knee, and it was obvious that the knee was hurt by the first and second incident. It wasn't clear that the injury was 10% caused by the first incident, 90% by the other, or 50-50, but we didn't have the burden of proving that. We just had to prove that both incidents happened, they were the fault of the defense, and that the combined impact of them was to permanently injure our client's knee. The case was defended vigorously in multiple ways. For one thing, the defense claimed that they did provide proper protection to our client by giving him a safety harness and having him be tied off so that if he did slip, he wouldn't fall off of the edge of the roof. And of course, that was true. They did. And we never contested that. We admitted and agreed that the client was wearing a harness and that he was tied off. And fortunately, when he slipped, he didn't fall all the way off the roof and down to the platform below. The problem, of course, was what the defense failed to protect him from is the risk of him slipping and falling and banging and permanently injuring his knee. So we claimed that having the client work on a wet, slippery, pitched roof alone was unsafe and was dangerous, and was not only negligent, but violated New York's labor law. And specifically, there's a labor law, and only lawyers in New York who practice construction injury law will necessarily even know of this law, but it's called Labor Law Section 241, subsection 6, where if you can prove that an industrial code was violated, and if you can prove that that industrial code provided a specific concrete command and that resulted in your client's injury, you can recover money from a general contractor. And here, we alleged that the contractor violated an industrial code that more or less says you can't have slipping hazards on construction sites. And this was a slipping hazard. It was a wet, slippery, pitched roof. We combated the defense to the case by saying, maybe you protected him against falling off of the roof, but you certainly didn't protect him from falling down onto the roof. And we ultimately settled the case for the client prior to trial, but fairly close to trial after a hard-fought litigation. The case was settled for a very substantial amount of money, enough money so that our client didn't have to ever work again if he chose not to or decided that he was unable to. It allowed him to breathe, be comfortable, support his family. It allowed him to live with dignity and without financial stress.